So here's the thing. You can't shoot somebody and then say you love them. We don't shoot people we love. So your relationship with her is over. And whether or not she wants to be in a relationship with you, that's besides the point. I'm not going to allow you to have any contact with her. Do you understand? Your recommendation?
Yes, Your Honor. She was previously ordered safety but failed to self-surrender, and probation feels that she could benefit from the substance abuse program due to her drug program. Problem.
All right. So I regret that I didn't know that you didn't surrender to safety, because if I would have known that, something else would have been done. You're looking at, if I don't continue, you're looking at up to 20 years in the prison. You understand?
Yes, ma'am.
Imagine standing in court, facing up to 20 years in prison, and everything hinges on the next few minutes. This isn't just another plea hearing. It's a case where one violent decision, a complicated relationship, and multiple second chances collide in front of a judge who isn't known for sugarcoating her opinions. Watch closely, because what happens later proves that getting probation doesn't always mean staying out of prison.
Deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it? And you're charged with the offense of aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty?
Here's an important legal point. Deferred adjudication isn't the same as walking away without a conviction. The judge is essentially pressing the pause button. If the defendant follows every condition, she may avoid a formal conviction. But if she violates probation, the court can find her guilty and impose any sentence allowed by law, up to the full 20 years in this case. That's a huge risk, and it explains why judges spend so much time making sure defendants understand exactly what they're agreeing to.
Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it? According to the plea bargain agreement, there's to be a $1,500 fine, affirmative finding of deadly weapon. State recommends deferred adjudication. There's an affirmative finding of family violence, and there's to be no harmful or injurious contact with Jessica Hernandez. Next, I'm showing you outside the plea bargain agreement. The state is recommending that your deferred adjudication be for a term of 7 years. There'll be a TAP evaluation, 150 hours of community service restitution in the BIPP course. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations? Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest? State, any evidence? I'm sorry, you're going to have to speak up.
No contest.
State offers State's Exhibit 1 and its attachments into evidence.
No objection.
Are you proceeding with sentencing?
Yes, Your Honor.
All right, so just so the parties know, I'm not going to agree to this no harmful or injurious contact with Jessica Hernandez. So if that's something that's going to break this plea bargain agreement, I'm not doing it.
It's not, Your Honor. That's fine, Your Honor. I told her that she is going to have no contact with her at all. And she has
Yes.
a reason.
All right. So here's the thing. You can't shoot somebody and then say you love them. We don't shoot people we love. So your relationship with her is over.
That may be the defining moment of the hearing. The judge isn't just issuing a legal order. She's drawing a hard boundary between emotion and accountability. No contact orders aren't about punishing someone's feelings. They're designed to protect victims and prevent situations from escalating all over again. Do you think the judge made the right call by taking reconciliation completely off the table?
No contact with Jessica Hernandez. And when I say no contact, that means no cards, no letters, no contact whatsoever, no sending a letter saying I'm sorry or any of that. Do you understand? There's to be 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. The BIPP course. Do you have any children? What do you do for a living?
Home care provider.
Not anymore. I don't allow people on probation to be a home health care provider. So how far did you go in school?
Dropped out like in 9th grade.
Why?
This, I didn't have my credits, so we dropped out.
That makes no sense. Nobody has credits to graduate from high school in the ninth grade.
I didn't have enough to pass my degree.
All right, there's going to be proof of employment within 30 days. There's to be no employment as a home healthcare provider or with minors. I'm going to ask for regular reporting by Zoom or in person. There's to be regular UAs. And I'm going to want field visits 2 times per month. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court? And probation, I'm serious about no home health care, no minors, and I'm going to do no unsupervised contact.
Listen to how detailed these probation conditions are. Employment restrictions, drug testing, community service, field visits, reporting requirements, even who she can work around. Probation isn't simply freedom with rules. For many people, it can be harder than they expect because every missed appointment or failed condition creates another path back into the courtroom.
Any weapons or ammunition, do you understand? If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, thank you.
Thank you, Mom.
Calling 2022 CR 6214, State of Texas versus Amberly Perez. Could I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense.
Eric DeWalt, I represent Miss Amberly Paris.
And are you Ms. Perez?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
All right, off the record for a moment. You all are going to have to move down there if you want to talk. No talking behind the court reporter while the court is on the record. And you'll need to ask the deputies to move your client. We're back on the record. Are you the same Amberly Perez who was placed on deferred adjudication in 2022 CR 6214 for the offense of aggravated assault with a deadly weapon on September 13th, 2022 for a period of 7 years?
Yes, ma'am.
All right, state.
Violated condition number 38 in Bexar County, Texas. The defendant, Amberly Perez, then and there failed to submit to drug testing as directed by the court officer, supervision officer for the month of June, August, and October 2023 in violation of condition number 38.
How do you plead to that? True or not true?
Your Honor, state waives all the violations.
Any objections?
None, Your Honor.
Did you understand by pleading true to violation of condition number 38, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 38?
Yes, ma'am.
Court will find violation of condition number 38 true. Is there a proposed agreement?
Your Honor, it's to the defendant to go to safety.
Your Honor, that is the proposed agreement. We are also in agreement. I know Miss Amberly is ready to make a change in her life, and we'd ask that she please be given this chance.
Fast forward, and here's exactly what the court warned about. Missing drug tests might sound minor compared to the original assault charge, but probation violations are about compliance. From the court's perspective, failing to report or test raises a serious question. If someone won't follow these conditions, can they really be trusted to complete supervision successfully?
What ends up happening is they continue to use, they don't report. So I'm going to give you a choice. I can sentence you to 5 years in the prison today, or you can go to safety.
Safety, ma'am.
All right. State your excuse. And probation, is this your recommendation?
Yes, Your Honor. She was previously ordered safe P but failed to self-surrender, and probation feels that she could benefit from the substance abuse program due to her drug problem.
All right. So I regret that I didn't know that you didn't surrender to safe P, because if I would have known that, something else would have been done. And that's my fault for not speaking to probation before then. If you fail to follow the court's orders and come back before me, if the state is able to prove up any allegations, you're looking at, if I don't continue, you're looking at up to 20 years in the prison. You understand?
Yes, ma'am.
All right, I'll deny the motion, alter and amend conditions to include safety, and she's to remain in custody.
Instead of sending her straight to prison, The judge offers one last opportunity through a treatment program. But notice the warning attached to it. This isn't a reset. It's a final chance. If she violates probation again, the court isn't limited to 5 years anymore. She could be facing the full 20-year sentence. Cases like this show how the criminal justice system constantly balances punishment, rehabilitation, and public safety, and that balance often depends on whether a defendant is willing to change.